Hello friends. What happens like if your SLP is dismissed? Today I'll explain you about this particular process. See, like the chances of getting SLP admitted are very difficult in the Honorable Supreme Court of India, because the Article 136, under which you challenge any of the magisterial orders or trial court orders or the orders of the or the orders passed with the Honorable High Courts, are challenged in the Honorable Supreme Court, which is not our right. It is the discretion of the Honorable Supreme Court to grant you permission or grant you a leave, so that it can be converted into an appeal. Otherwise, the chances of appeal in the Honorable Supreme Court are very rare. Even if a person is convicted, let's say like he is convicted by the trial court as well as the High Court, when he comes for an appeal to the Supreme Court in the form of SLP, there is no guarantee that he has got some kind of right or something, and it has to be heard and it has to be admitted at the threshold, that is at the time of hearing itself it can be dismissed. So this is the first and foremost thing. The chances of getting an SLP admitted are very rare. You need to understand that. Then what are your chances? The same division bench, that is the bench containing on two honorable judges which has heard your SLP and dismissed it, will again review it under Article 137, which is again much more rarer category. All right, and you have to make out very grave substantial question of law has to be arising, and there has to be error apparent on the face of the record. And if at all you succeed in such thing, then the review petition can get admitted, but again the chances are very bleak, very low. And then coming, what next is your remedy? Your final remedy will be through a curative petition. This petition is will be heard by the topmost 3 or 5 judges of the Honorable Supreme Court, wherein like the Honorable Chief Justice of India will be adjudicating this particular curative petition. So you have bright chances at least for the admission of the curative petition, but it has to be signed by 2 senior designate advocates, who has to, in other words, they have to certify that your review petition is fit for a curative petition. So they have to recommend it, and then only it can be filed in the Honorable Supreme Court for in the form of a curative petition. And there are 2 things in this. Number 1, like you can request for an open court hearing, or else number 2, like you can request for in-chamber adjudication. If it is in-chamber adjudication, they will go through the record, and if at all there is any error apparent on the face of the record, they will consider it. Otherwise, again, your last chance also will get dismissed. So this is how the process of filing an SLP as well as review petition as well as the curative petition happens. It doesn't matter for people who are challenging a few orders which are not that much, might not be that important, or else in other words I would say, like if somebody is not convicted yet, then it might not make much difference. You can always come back to the High Courts even if your SLP is dismissed, because the orders of the SLP dismissal are not covered under the Article 141 of Constitution of India, which makes the orders and judgments binding in the entire country. Only if a leave is granted and your SLP is converted into an appeal, and an orders or judgments are passed in appeals, then only those particular judgments or orders will become binding in the entire country. So you can be you can always explore your further options, or the best way to argue in the Honorable Supreme Court is, you can always request, if the bench is not inclined to interfere with the order, then you can always request them to remand back your matter to the High Court or else to the trial court. That they will be much obliged to entertain it, because there is nothing that the Honorable Supreme Court will lose if they are redirecting the matter to the courts below. Second, they can always consider such kind of request, and they can always say, take a fresh look at this matter, or else try to adjudicate on merits. Once again you go through this, such kind of reliefs you can always you can obtain. So there is always a window. You need to argue in such a way that based on the mood of the judges and all, and rightly pointing out the right questions of law at the right point of time, you can succeed. you always have to make out just one or two three questions of law which you can raise, because nobody no bench will hear more than that. If you are able to raise at least 2 or 3 points, that itself you can think yourself pretty lucky in that particular aspect, because time is extremely precious in the Supreme Court, because the volume is in thousands per day. The petitions that are filed, and per bench adjudicates nothing less than 500 petitions on an average, and getting heard, if you think that in given few 6 or 7 hours they are going to listen to you for hours together, then you are thoroughly mistaken. Hardly you will get is 3 to 5 seconds. So 3 to 5 seconds in the miscellaneous days, that is at the time of admission, and you can drag it to maximum 1 or 2 minutes, maximum if you are lucky enough 3 or 4 or 5 minutes. But there's no guarantee. Just because the bench has heard you at the miscellaneous hearing at length for 5 minutes, it does not guarantee you guarantee admission. All right. So, and the next point, like in the non-miscellaneous hearings, the Supreme Court will entertain you for more time. They will grant you at least few minutes to be heard. Okay, even if you are given let's say more time, it does not mean that you can give lectures in the Honorable Supreme Court. They are least interested in that. The best way, or the best and appropriate and professional way of arguments is only to the point question of law, where the lower courts or the honorable high courts have committed errors. Only those points you have to bring to the notice of the Honorable Supreme Court. These are the question of law on which the honorable lower courts have committed the error, and this Honorable Supreme Court may take a look at it and consider it. This is what you will say. And if they are pleased and if they are on your side, then they will go ahead and you will get a favorable order and you will get a relief. This is how it works. And there are some counsels who just because they have got the hearing with the honorable courts, whether it's lower court or high court or Supreme Court, they keep on giving lectures and arguing. Just because they have the communication skill, it does not mean that you can bombard and bang the ears of the court. That's not correct way, because a lot of times, like I have seen in the courts, various high courts and the Supreme Court also, the decorum of the court is very important. All right, we must respect the space of the judges. Just because you being heard, that itself is the greatest privilege what you have, because there are millions of people waiting for us for the justice. Justice has to be delivered to each and everyone. There are more serious cases than ours. We must understand that. Okay, and in that particular way, we have to just focus on professionally. I would rather say focus on few best points, 1 or 2 or 3 or maximum 5 best points quickly within a minute or half minute. You can whatever you can say, you can quickly say and try your luck and try to convince only based on those points, rather than arguing for lengthy time and wasting the time of the honorable court, and you will be completely penalized. There will be hefty fines. In the honorable high courts are nowadays imposing costs of 50,000 and lakh onwards, anywhere up to 10 lakhs or even 15 or 20 lakhs also. And honorable Supreme Court starts with 5 lakhs and there is no end. There are 25 lakhs is a common thing. Either if you shout at the honorable Supreme Court, if you raise the pitch of your voice and argue in the courts, that's a very bad manners, and it's not part of the court decorum. It's not good of it's not a good part on a good counsel. A good counsel is a person who just tries to gauge the mood of the honorable judges and sing to their tune. Okay, you have to try to convince them. You have to convince them in a very, very polite way. It's nothing but begging. There's nothing wrong. If you are begging the honorable court and getting some favorable orders for him, then you are a hero. As simple as that. Because the honorable courts, they depend on the advocates. Advocates are the main people who will take the best points to the court, and they will convince the court, and on the basis of the question of law and legality. Facts are the least important things what most of the advocates they commit. They keep on arguing on lot of facts, and even some party in person petitioners also, they argue at length and they talk unnecessary nonsense about the facts. They have got the case has got nothing to do about the facts, because you must understand that fact finding courts are only the trial courts, and these facts have to be established. The relevant facts and the facts in question, facts in issue, have to be thoroughly established by way of your evidence. Various forms of evidence is there. Based on that evidence, you have to establish in the trial courts. So once you cross the barrier of the trial courts and enter into a domain of the constitutional courts, whether it's the Honorable High Court or the Honorable Supreme Court of India, they are not fact-finding courts. They are totally like the courts which deal with the question of law. So you need to respect that particular domain and you need to argue only on the question of law. If facts are only for the basic understanding to the honorable constitutional courts, whether it's High Court or the Supreme Court, you will just brief them within 10 seconds or 15 seconds what is the case. Okay, that's all. Like it's a case of a murder, or it's a case of a homicide, or it's a theft, or it's like a civil dispute, or it's a case of a partition, or it's a original suit for recovery of money, or suit for recovery of possession, whatever it is. You have to briefly explain and whom are you representing, and the original plaintiff or defendant, or the accused or the complainant. In that way you have to briefly you have to tell them, and the sections, and within everything should happen within seconds. And then straight away the question of law, where exactly the high courts have committed the mistakes. And if you raise that particular point before the Honorable Supreme Court, then straight away the chances of getting the petition at SLP admitted are very bright. Notice will be issued to the other party, urgent notice will be issued. They have to report back in 4 weeks, or let's say 6 weeks. If they don't report, it will be adjudicated in your favor. There are very bright chances. Even if they report, if you have a strong advocate, counsel, who can put your points across, let them argue for length, or doesn't matter. If anybody who is arguing at length, that does not mean that they are going to get order in their favor. They are arguing at length means they are at peril. They are digging their own ditch. They will fall into their own ditch. As simple as that. That's not the correct way of arguments in the constitutional courts. All right, you need to be straight to the on the money and on to the point, straight away to the point on the question of law, where the law point or whatever the law has been violated, and whichever sections have been violated, only that particular, and whichever of those grounds the Honorable High Court has not considered, or they have considered and they have erroneously passed an order, then only you will have bright chances of getting the SLP in your favor. And for the people who are getting tried under heinous offences in particular, I would suggest you try to hire or engage the best counsels in particular lower court itself or in the high courts, and try to get rid of your problems there itself. Because once if you are consecutively convicted both the courts, then the chances of your appeal, that is nothing but an SLP, getting considered by the Honorable Supreme Court are very less. If that is the case, then you have to go through the entire sentence. If it's a life sentence, death sentence, or any type of sentence, you have to undergo. All right, I would give you an example. Like in some times of check bounce cases, a person gets convicted, the check amount can be less. It can be hardly 10,000 or 50,000 or lakh of rupees. But there are convictions on him. The trial court has convicted, sessions court has convicted, finally the high court also has convicted. Then what is the point? Like the Supreme Court do not entertain such kind of things. At the threshold, you are tata bye bye, dismiss. Straight away it will be thrown into air. Your file will be thrown into air. Then what option you have? And if at all, then you try to convince the Supreme Court and try to go for a compromise with the other party. The value of this 10,000 or 50,000 will the other person will not agree for 10,000 or 50,000 or lakh or 5 lakhs. He will demand 100 times or 1,000 times more than that, because you will be going to jail. He will say like, you better go for sentence of 2 years or 1 year. I'm least for that, I'm not interested. So this is how it happens. The gravity will become more. The more and more you get convicted in the courts below, the gravity of your case will be very high, and to bring you out will be very, very tough. So the best advice is to try to get rid of your criminal cases in particular in the courts below or in the high courts itself. No matter whatever the costings are coming, you pay the best counsels and you engage them and try to get rid by hook or crook in the courts below itself. Don't keep much hopes on Supreme Court, because you might be thinking that if you go to the Supreme Court, you might get relief because it's the highest thing, because anyhow in your view, the judges in the trial court or the honorable judges in the high court might have done mistakes, because you dwell on facts. They don't dwell on facts. The courts always dwell on the evidence. Evidence, Indian Evidence Act is mother of all acts. There are 6 to 7,000 central acts and thousands of state acts. Apart from that, you have all the three codes. So all these are dependent entirely on the Indian Evidence Act. What evidence you bring to the table, what evidence you bring to the bench, all that matters. So everything will be depending upon the evidence what the other party is putting on, what you are putting on. Based on that only the adjudication will take place. So it's all about the evidence that can include oral depositions, it can include documentary evidence, it can include medical evidence, it can be electronic evidence, no matter what, but it has to be evidence. So evidence is the main thing. So try to get rid of all your cases, whatever, even if it's civil or criminal. Try to get rid in the courts below, in the lower court or high court, to engage the best counsels. There at least I can say, like, not like unlike Supreme Court of India, you have little bit decent time to argue in those courts. But those courts also nowadays have become very busy. In each and every magistrate court, like hundreds of cases are listed. In the honorable high courts also, like 4 to 500 or 700, 800 or 1000 cases are listed sometimes. It won't reach hardly in each court, like some judges do 100, some do 50, some do 200. That all depends on that particular roster. That is, roster is nothing but the kind of portfolio, you can say, like municipal administration or home or criminal admissions, civil admissions, civil appeals, criminal petitions, this kind, or bails, these kind of roster it is called. So various departments, medical and health, or else like you have health, education, that universities and all will be in that. So various councils will also be there. So various rosters will be there. So various judges will be adjudicating these matters, and will be hearing those. In high courts, what you can get is you can get at least at the time of admission. Sometimes because the notice has to be ordered, some judges do not entertain, not even 10 seconds in that case, or half a minute. Okay, they will straight away issue urgent notice, and the next hearing, once the both parties come and once the counter is filed, then they will take up a hearing, and it can minimum you will get 5 to 10 minutes, and the maximum you can drag it if the matter is so of grave nature and all. It might go half an hour or 1 hour, and that's it. But that also will be not suggestible, because arguing at length for half an hour or 1 hour does not means that you will get a relief. People, the counsels who do not know the way of arguments, they'll keep on arguing at length, because you need to understand, if you switch on the prime time debates on the television, particularly in any regional or national television, like people will be shouting, and the anchor will be listening, and you don't understand what the proceedings are. Both will be arguing, like both the political parties, let's take an example, both will be arguing on one particular point, and we can't understand who is talking, who is trying to make what kind of point. This is not the way that happens in courts. Even if it's happening, it's unfortunate. The judges will come down heavily. We have to be very careful, and we have to argue to the point. And to the point means on the merits are based on question of law first, then the facts doesn't have any much kind of, unless and until the trial is complete and a judgment is passed, the facts will not have any bearing. You need to understand that facts doesn't contain much of importance. They have minimal importance. The most important is a question of law. For example, if a person has committed a murder, genuinely has committed a murder, and it's a true case, and everybody knows that, it's all in the media, but the court will not get influenced by such kind of things. What is on paper, what kind of evidence has been collected, that is the main thing that the court will examine. If there is evidence, then only there is a point of conviction. If there is no evidence, okay, to substantiate and to prove it beyond any reasonable doubt, so he will be acquitted. So it's as simple as that. So when it comes to defense, like this is how it happens when it comes to and one more thing, like I would like to tell you, like there is a growing trend now amongst the courts in the entire country, whether it's the lower courts or the high court or the honorable Supreme Court, particularly in criminal cases. You can understand and you can see that there is a growing trend of convictions. Earlier the convictions were very low, very low, that's true. Like if you see police cases, the convictions are hardly 1%, 0.1% or 1%, not even that much. But now it's growing like anything. Particularly in CBI cases, the conviction in ED cases, it's above 95%. So in the same way, you have various departments, police departments like economic offences wing, as well as the crime branch or the criminal investigating department. So these kind of branches are there. Special branch, whomsoever is prosecuting, anti-corruption bureau. In these kind of cases nowadays, the conviction rate has drastically increased. That's because the screws are getting tightened up everywhere in the country. So it's the better advice is to try to get rid of cases at the lower level itself and try to engage the best counsels and get acquitted, because the chances once you go higher and higher, once you are convicted, and the saga will go on. There is no end for that. You will end up in jail, but you will not get the relief. So this is what is happening. And when it comes to the complainant side, yes, I agree, prosecution is very difficult because police are notoriously famous. They are notorious for committing blunders. However, the best case they have, they commit n number of blunders. Unfortunate. Why? Because in the Indian Police Act, the police have been given sweeping powers with them as far as the investigation is concerned. So the police have got sweeping powers, and whatever they do, it will go on. There is nobody to question, because they high-handedly they do the investigation. Whether sometimes they botch up the investigation, sometimes they do or do commit horrendous blunders, whatever it is. Unless and until you have a private counsel for yourself, you do not know what kind of blunders they are committing. The main reason for this is police are not experts in law. You need to understand, the only professional who has got complete command, at least decent command over the law, is a advocate only, number one. And number one is judges, and no doubt about it, because they are more experienced and they have more knowledgeable about this. Always judges come first, then comes the advocates. And last thing, the police, I would say they hardly have anywhere between 10 to 20, 30% of knowledge about the law, because they don't know maximum law. There are some people who are LLB as well, and they have decent amount of law knowledge. That will be at the higher levels, that is of IPS cadre. Therefore, the people who are at the investigation and ground level, the sub-inspectors or inspectors or SHOs or the assistant commissioners of police, they are having not that much of knowledge of law. Therefore, the blunders will definitely take place, and those blunders will give great opportunity to wriggle out of the criminal case for the accused, and as well as it will cause a big havoc for the complainants, that accused is not getting convicted and he is not getting justice. So in such kind of scenario, complainants should hire good counsels who can so that the complainant will not depend on the public prosecutors or the government leaders or the police to establish your case in the appropriate way, and to take your case to the honorable court in an appropriate way, to brief the honorable court in an appropriate way. You can always engage a private counsels and take it forward. That's a good idea. Then there is a chance of complainants getting justice. And defense counsels, anyhow they are private people, they can always get strive for justice for the accused. And last thing I would say, it's a game of evidence and best presentation by your counsel. So if at all your counsel is presenting your case in the best possible way on merits, on the questions of law, on good legal grounds, legally tenable grounds, then it's inevitable. Justice will be delivered to you, because it's an open court and the courts believe on evidence and they go totally on merits. So now coming back to the Supreme Courts, we have started with SLP and review petition and the curative petition again. And these three are the types of petitions. Whichever orders you want to challenge in the Supreme Court, the High Court order or judgments, or lower court orders or judgments, you can always you can take it to the Honorable Supreme Court. There is no issue. But directly, if you challenge a lower court order in the Supreme Court, they will send it back to the High Court. So it's advisable to come with a High Court orders to the Honorable Supreme Court, so that you can take it forward for the best way of adjudication. And only the people who have knowledge in the question of law, that is legal points, only those people can secure justice for you, and at the same time they should be in a position to argue well. And also, not only the arguments, your drafting itself should be excellent, because the honorable Supreme Court judges, they read, once they go back home, all the next day files will be taken to their home. They will be reading late till late night, or from early morning till they come to the court. They will take some time out and they will read all your petitions. And I was in many times I myself was surprised and shocked, because the honorable judges know more information than I know in my particular case. This is how it happens. So you have to be thorough with your case. Everything has to be on your fingertips, the law points and the facts of your case, and whatever the proceedings have happened everywhere. And because they will come out with weird questions, no doubt about it, they will not ask you easy questions to answer. They will catch you with a tight question, and that is the end of your SLP. Straight away it will be dismissed there itself. So that's why you have to be very, very well prepared. If your drafting is good, then the chances of your SLP admission are very high. So that I would say 70 to 80% of your marks will go to the drafting itself, and only 10 or 20% for the argument. Okay, so because the honorable court judges will are already acquainted with your petition very well, they will be dismissing almost hundreds of petitions every day, but they will read everything, and they know the loopholes in each and every petition. That means they have got a point to dismiss. So we cannot blame the court on that particular thing. We have to make out if there is a case to be made out on that particular point. If you don't have an answer, then you don't have any right. So this is how the nuances of law are. Okay, so if a person who is a convict is coming to the Supreme Court and is not able to make out a case in the SLP, then he has to languish in the behind bars forever. As simple as that. Nobody will give relief. Even the honorable president will not allow any kind of mercy petitions. Then there is never in the history of the country, nobody will be given such kind of things. It's very, very rare. Okay, so don't try to expect such kind of things. After curative petition, you can put up a mercy petition with the honorable president, but the chances are again very, very bleak, because whatever the Supreme Court, the honorable president will never turn it around. So you need to be aware of it. So it's all about drafting and arguments, and these are the things, my dear friends. Thank you so much for your audience, and you need to understand that it's all about good drafting and good arguments. It's not just like an advocate on record can help you. They are specialists in mostly in the filing of the cases. They are very essential. They are the face of your case. But the most important people who can get justice for you are the people who draft it and the people who argue for it. So you can always contact us. We are at Sridhar Dayal Law Firms. We are located in Hyderabad, Delhi, and Bangalore also now. So we can help you out with any type of filing of SLP cases and arguments, SLPs or contempt petitions in the Honorable Supreme Court, transfer petitions, writ petitions, and at the same time contempt petitions. All these kind of things we are specializing, and we can help you out with the drafting or the arguments. We various senior designate counsels are also attached with us. We can take their help also for securing justice to you. So you can be assured of a professional, highly professional assistance from our side. We believe, because we have trust in the Honorable Supreme Court of India and Honorable High Courts. We practice across the High Courts in the country. So wherever you have any major issue, you can always approach us. And moreover, we specialize in the criminal side particularly, and apart from that, we also specialize in land and property disputes which are above 5 crores of net worth. So such kind of things we will always be glad to take up. And we also take up prosecution in various cases like economic offences, money laundering, or benami transactions, or scams, such kind of things also. Prosecution, not defense. In these kind of offences also, we can help you out in taking the culprits, bringing the culprits to justice. So thank you, my dear friends. Have a nice good day and have a nice evening. Thank you.